In most American cities, a basic biological need can escalate into a criminal misdemeanor in under 10 minutes. There is no unified federal law against urinating in public. Instead, enforcement is managed by a hyperlocal patchwork of city and county ordinances on public nuisance, disorderly conduct, or indecent exposure. This creates a localized trap, where the severity of the charge depends entirely on which specific city block a person is standing on when they run out of time. Los Angeles Municipal Code Section 41.47.2, passed in 2003, is the primary tool for this enforcement. It explicitly bans the act across all public spaces: streets, sidewalks, alleys, beaches, and parks. Yet the city's own books contain a sister provision, Section 41.47.1, which outlines a business's obligation to provide restroom access. Public records suggest this requirement is almost never actively enforced. Cities fund the police to monitor the sidewalks, while leaving the obligation to provide actual plumbing completely ignored. Stepping onto public transit introduces a new layer of legal risk. In California, Penal Code 640 creates a separate criminal framework for any bodily function performed inside a transit vehicle or facility. Crossing onto federal property, like a courthouse or post office, triggers Title VI of the Code of Federal Regulations. Under these rules, inappropriate disposal of bodily fluids is a federal offense, carrying a fine and up to 30 days in prison. Legal density compounds as you move through the city. A citizen cannot navigate a normal day without passing through multiple overlapping zones of potential criminalization. The Supreme Court solidified this local authority in the 2024 decision City of Grants Pass v. Johnson. The court held that the Eighth Amendment does not prevent cities from criminalizing conduct tied directly to a person having nowhere else to go. This ruling effectively sealed the cage around individuals caught between a lack of public plumbing and a wealth of local ordinances. In 2025, the Ohio Court of Appeals heard the case of State v. Briers. A man with a documented bladder condition was waiting for a bus, couldn't hold it, and was charged with public indecency. Despite his medical evidence and the transit delay, the court affirmed his conviction. A dense stack of appellate decisions across Minnesota, Oregon, and California confirms a consistent pattern of courts rejecting medical necessity as a defense. State-level restroom access acts like Alley's Law in Illinois offer limited relief. These laws only protect a narrow demographic with specific, qualifying medical conditions like Crohn's disease or ulcerative colitis. For everyone else, the justice system functions as designed, treating common-sense human urgency as a punishable offense. This reveals an inverse relationship between physical infrastructure and legal density. As public restrooms disappear from the map, local ordinances grow to fill the void. The cost of a missing physical wall shifts entirely onto the person who needed it. Society has opted to substitute the mechanics of the justice system for the basic requirements of public sanitation. This structural failure targets the most vulnerable: the unhoused, the elderly, transit riders, and those with chronic illnesses. American law criminalizes the symptom because it refuses to fund the solution. Every municipal code and appellate ruling confirms the systemic choice. These are the documented realities of the law.